So, as Amy was saying, we are going to speak about the new ministerial resolutions. They were announced in October last year, and to be effective from January, 1st of January this year, and they were fully published in January 2016. Now, technically, they don't amend the labour law. So we still have the federal labour law, which is dated 1980, was amended a couple of times, but is largely unchanged for quite a long period now. And what the ministry has done historically is that it issues these resolutions from time to time. Now, what I'd like to do is just set the scene where the resolutions have come from, where we see them fitting into what the Ministry of Labour, now renamed, as you all know, the Ministry of Human Resources and Emiratization, what they're trying to achieve. I'll then hand over to Rachel Smith, who will talk about the practical implications of the resolutions. There's now an offer letter and an employment contract, a different employment contract to what we're all used to. And then Samantha's going to finish off our formal presentation by talking about the effect that the resolution had on termination of employment, how that's going to have to be managed going forward. So what are these resolutions? There are 3 resolutions, and they are about recruitment, employment contracts, and termination. And we can see these resolutions as fitting into a process which was started by the Ministry of Labour in 2010. So in 2010, at the end of 2010, the Ministry of Labour published 3 or 4 resolutions at that time. And what they did was they introduced a new kind of categorizing of the labour market. So as you all know, we now think about the labour market in terms of skill sets. So in those resolutions, the Ministry of Labour defined skill set 1, 2, and 3 according to level of qualifications. So was the candidate someone with a high school diploma, a graduate diploma, or a university degree? And these resolutions are a continuation of that process. So what these resolutions are really aimed at are skill set level 4, which are the unskilled. And the resolutions are aiming to address what many have identified as issues for this unskilled category. Let's call them somewhat abusive practices that have happened, such as promising a certain package, and then when the person arrives in the UAE, revising that package, and suddenly somebody's on a totally different offer than what they thought they would be on. So it's, I think, very much a positive step, but unsurprisingly, there are a lot of unanswered questions, and we're really going to have to see what happens in terms of how the ministry approaches the resolutions, how they implement them, how they're supposed to be placed, and what happens in practice. Now, one of the biggest things about the resolutions is that they are Ministry of Labour ones, so they don't technically apply in the free zones. So for any of you who are within free zone authorities, within free zone areas, these resolutions, strictly speaking, don't apply to you. Now, there is quite an interesting provision in the DCC employment and sponsorship regulations, because it defines the labour law as being the federal labour law together with all ministerial resolutions and decrees. So at least within the DCC free zone, there is a recognition of these ministerial resolutions, and that they should, at least in spirit, be used by the free zone authority, be implemented within the DCC area. Now, the other free zones don't contain that section in their employment regulations. However, we may see some of the free zones starting to adopt the spirit of these resolutions. And so to hand over, so that we really examine the kind of detail of the resolutions, I'm going to hand over now to Rachel.
Alrighty, so Sarah has helpfully introduced the new ministerial decrees that came into operation in October. They're aimed to promote transparency and labour mobility, and took effect from 1 January this year. As Sarah mentioned, they don't officially amend the labour law, and they're only applying to employers in the Ministry of Labour jurisdiction. So as Sarah mentioned, there's a new concept, there's an offer letter. It's a mandatory part of the sponsorship process. So when you offer employment to a new employee, you need to provide this prescribed Ministry of Labour offer letter, and also it comes with a detailed annex, and we'll discuss the annexes in detail later. It must be signed by both parties and then filed with the Ministry of Labour, and the subsequent template Ministry of Labour contract, which is also changed, issued must reflect the terms of the offer letter. And they can, unless the changes are to the employee's advantage and approved. So the Ministry of Labour prescribed form contracts will all be used to the previous Ministry of Labour contract. It was very short and sweet. It was a 2-page long document. Now we have 3 separate prescribed form contracts, one for an unlimited term, one for limited, and one for the renewal of a limited term contract. And no new clauses may be added unless consistent with the labour law and the remainder of the Ministry of Labour contract and approved by the Ministry. So the new contracts, what do? They allow greater flixibility in terms of remuneration. So you can insert things such as commission. They also set out a number of optional allowances such as school fees, flights, phone, etc. Even a gym membership or gym allowance. So when you're going through those, there's no requirement to offer those allowances, so you can simply leave it or insert 0. And they also provide detailed supplementary notes in an annex. So in terms of the annexes, there are 6 of them. If you go on the Ministry of Labour website, then there's a drop-down box and you can select the annex for each of these 6 options, and there's a number of different languages that they're issued in. So you can select any of those and they're to be provided with, the first 2 are to be provided with the job offer, and the latter are with respect to the contracts. So they're quite extensive. They're between, in the English translation, they're between 22 and 23 pages. So that's quite a lot of information you're giving your employees. So we really have to drill down into those as to what they say. So, practical consequences. So we've got the labour law on one hand, it stays as it is. Then we've got the Ministry of Labour decrees or resolutions. And so practically speaking, you're providing your employees an offer letter with the accompanying annex, and then you're subsequently providing them with a Ministry of Labour contract that's consistent with the offer letter and another annex, so they're getting a double whammy. So what do these annexes say? Well, as I said, they're quite detailed, they contain a lot of information. To a large extent, they're really consistent with the labour law, they repeat the labour law, but there are some instances where they're not really consistent. And that's, as Sarah mentioned, we're going to see moving forward how that's interpreted, how it works in practice. So we're going to focus on some notable provisions. We could talk about the annexes for quite some time, so we've just picked out some key provisions to be aware of. When you read through the annexes and also the contracts themselves, you'll see that they very much focus on this consensual, voluntary, transparent relationship between the parties. Particular labour law articles with respect to termination are extracted in full, and they obviously differ between your limited contract and unlimited contract. And just some particular examples, previously under the system, a number of employees, they probably didn't access a full copy of the labour law. So even though provisions in the annexes repeat the labour law, employees may not have actually been aware of their rights or their obligations or responsibilities. So now that they're extracted in full or they're repeated, that means that employees are going to have more information about their rights, and it may mean that they raise more with their employers. For example, the annexes say that employees are entitled to official leave with full payment on specified public holidays. That's actually stated in the labour law, but in practice, if public holiday falls on a weekend, then there's no obligation to give a day pay in lieu. A number of employers choose to do so, but employees may basically arc up and say, well, you know, it says that in my contract, so it'll be interesting how that's interpreted moving forward. Another interesting point is the overtime provisions are extracted in quite a lot of detail, but there are no exceptions referred to. So with respect to very senior employees that fall in that category where the overtime provisions don't apply under the labour law, it will be interesting to see how that is interpreted moving forward, because essentially you have an annex, which is part of the contract, saying these are your overtime provisions. How is that actually going to be interpreted? Does the employee have a contractual right to those now, even though they're expressly excluded under the labour law? Also, helpfully though, there's no time gap between renewal of a fixed term and a new subsequent fixed term contract. So the prescribed form contract simply says the day after it ends, the new contract starts. Now, one of the things that the annexes have tried to do in some places is clarify the position. It will be interesting to see whether it actually does clarify the position or whether it's just complicated matters further, because obviously you still have the labour law in place. So with respect to annual leave, during employment it's quite clear that when you pay out annual leave, it's going to be basic salary plus your housing allowance if there's any. And that's been consistent through the Ministry of Labour annexes, the Dubai Court, the Abu Dhabi Court. What's interesting is how do you pay out annual leave upon termination of employment? Under the labour law, and there's a bit of, with the Arabic original document and then the English translations, there's been a bit of confusion about this, but essentially it's full remuneration. In the Ministry of Labour annexes, it's basic wage. So, and also that's not actually defined, that term. I think it's defined as basic salary. Or by the Dubai Court, from our review of Court of Cassation judgments, has looked at that annual leave upon termination will be paid out on basic salary only, whereas in the Abu Dhabi Court, it's been a bit different. There are some reported decisions that say that the basic salary is going to be paid plus the housing allowance, where it's clearly provided for in the contract of employment. So it'll be interesting to see how the courts actually interpret this going forward. At the end of the day, it's really about how the courts will interpret it. Now moving on to employee obligations. This is in the Ministry of Labour annexes. Helpfully, there are a number of obligations set out that were not, that obviously weren't previously in the contracts. It expressly states that employees shall not work for third parties even during leave, except in circumstances permitted under the applicable regulations, so if you've applied and there's been an approval. Also helpfully, upon the employer's request, the employee shall undergo medical examinations where they're necessary for the benefit of the work, prior to and during employment. Also, employees expressly are responsible for fees for obtaining ID cards for themselves and their family. And also there's an obligation to inform the employer of his contact information, and then the employers to provide that to the ministry. One thing that definitely stood out for me, as if you've been involved in litigation onshore in the UAE, there's no obligation to the court, no obligation of disclosure, so if you get in a litigation situation, it can often be quite difficult because there is no obligation. There's only really an obligation to submit documents that support your position, and sometimes some key documents may not be submitted by one party to create your argument, to put forward your submissions. The Ministry of Labour annexes expressly state that the employer shall not deliberately submit malicious reports against the employer, and if the Ministry of Labour refers an employee complaint to the court, the employee shall register his complaint within 2 weeks of the date of referral, and also settle his status by cancelling his permit and moving to another employer, or leave the state within no later than 2 months after the issuance of the final or conclusive judgment. So we've got a bit more clarity. There's further obligations being placed on employees in that regard. I'll now pass over to Sam, who's going to touch on the termination provisions in more detail.
Good morning, everyone. So as Rachel said, I'm going to talk about how the ministerial decrees and the new contracts impact upon termination. And as we've already heard, there are now 3 contracts. There's the unlimited term contract, there's a limited term contract for the initial term, and there's a limited term contract for the renewed term. And they're all now treated slightly differently, so we'll look at each of those in turn. So starting first with the unlimited term contract, and really it hasn't changed significantly. As we'll see from the slide, we've still got the minimum 30-day notice period. An employer can still terminate without notice under Article 120, so for a gross misconduct reason, or with notice for a valid reason. And an employee can still terminate on notice or without notice where the employer breaches their legal or contractual obligations. The key change is that the ministerial decree has introduced a maximum 3-month notice period. And really, I think this is only going to affect more senior employees where notice periods of 6 months, possibly higher, are quite common. And it could potentially cause some issues, because if you're looking to recruit a senior employee from overseas or from one of the free zones, for example, where they're likely to be on a 6-month notice period, that might cause some issues. The other interesting point to come out of the new Ministry of Labour and limited term contract is that notice periods must be the same for the employer and the employee. So from time to time we would see employers trying to agree, say that they have to provide a 1-month notice period, but that the employee has to provide a 3-month notice period, for example. And the new Ministry of Labour contracts have confirmed that that's not acceptable. The limited term contracts, this is where we've seen the biggest change. And I suppose the initial fixed term really still operates in the same way as we're all used to, in that both parties are essentially fixed in for the period and can't terminate the contract within that period. But the ministry has now introduced this concept of a renewed term contract, and the parties have a lot more flexibility within that period to terminate the contract. So just a reminder of the position under the labour law, which, as we've heard, still stands, hasn't been amended. So the duration of a limited term contract is limited to 4 years per contract. It can be renewed for further periods. Termination isn't permitted by either party, and where either party does seek to terminate the contract prior to the expiry date, compensation is payable. And that compensation is for 3 months or for the duration of the contract, whichever is shorter. Where the employer has terminated the contract, it's at full pay, and where the employee has terminated, it's at half pay. And either party can terminate without notice in certain circumstances. Under the ministerial decree and the initial term contract, the duration of the contract is now limited to 2 years. And I've put a question mark there as to whether it's fixed, because the document that we've seen, it appears that the contract has to be for 2 years. So it certainly can't exceed that, and it appears that you don't have an option to insert a shorter period. So you can't, for example, enter into a contract for 1 year. And everything out, in all other respects, it's as per the labour law. So you still can't terminate it prior to the expiry date, and if you do, then compensation is payable. The renewed term contract, you still need to insert a period, and what we're talking about here is the initial term is expired, you enter into the second contract for further periods. You still need to insert a duration, and that still needs to be no more than 2 years, but it appears that you have some flexibility to make that for 1 year, for example. And interestingly, you can now agree a notice period. So that notice period can be between 1 and 3 months, and either party can then terminate the renewed contract by providing that period of notice. You can also agree compensation that's payable where either party terminates on notice, and that compensation can be anywhere up to 3 months' pay. That all sounds relatively straightforward, I think. The difficulty we have is that the labour law hasn't been amended. So those provisions I talked about, which say that if the employer terminates the contract early, compensation of up to 3 months is payable, still apply. So how that's going to interact with these new provisions regarding contractually agreeing compensation is unknown, frankly. So if, for example, you contractually agree that 1 month's compensation is payable where the employer terminates the contract early, where does that leave the employee? Can the employee still go to the Labour Court and say, well, this provision of the Labour law says I'm entitled to 3 months compensation actually, so I want my 3 months? And I'm afraid we don't have an answer at the moment as to how the courts will interpret that. In terms of your contracts at the moment, if you have contracts for a limited term for the renewed period at the moment, if you don't have a notice period in there, then a 3-month notice period will automatically apply. And similarly, if you don't have any compensation provisions in there, which we wouldn't expect to see, the 3-month compensation will automatically apply. So you need to think, if you use limited term contracts, you need to think about whether you want to include notice provisions and compensation provisions to avoid this 3-month period automatically applying. If you have supplementary company contracts in addition to the Ministry of Labour contract, which I'm sure many of you will have, you should also think about whether you now want to have 2 template limited term contracts, so having the initial term and the renewed term. The key difference being that you would have the different notice provisions in the renewed contract. And that last point there really questioned whether you would want to continue using limited term contracts. In our experience, they're not used particularly frequently anyway, or certainly not as frequently as unlimited term contracts, safer in certain sectors. But I think given the renewed contracts are now effectively operating in a similar way to unlimited term contracts, and given the big question marks we have about how these are going to work going forward, I wonder whether we'll see a reduction in the number of employers using them, certainly whilst we get a bit more certainty. A couple of other notable points set out in the annexes to the Ministry of Labour contracts in relation to termination. The first one really is just a note of caution. The annexes seek to repeat what Article 120 of the Labour law says. So Article 120, as I'm sure you'll all be aware, is the provision in the Labour law which sets out the circumstances in which an employer can terminate an employee's employment without notice, so gross misconduct effectively. The annexes try to restate them and give a little bit more clarity, but there are certain cases where I think as employers we just relied on that wording, we might get ourselves into issues. Article 120 is an extremely high hurdle, and in practice it's very, very difficult to show that an employee's conduct falls within this high hurdle. And for example, at one point in the annex, it talks about an employer being able to terminate an employee's employment without notice where the employee fails to perform their basic duties and is warned about this. And as an employer looking at this without knowing how high a hurdle Article 120 is, you may think that, you know, if an employee isn't performing satisfactorily and you warn them about it, then you can terminate them without notice. And that isn't the case. It doesn't amend the Labour law. It's still very, very difficult to terminate under Article 120. The other point I just wanted to flag, and it's a bit of a strange provision in the annex and presumably just an error. The annexes say in relation to the limited term contracts, so I'll just take a step back. So under the Labour law, the position in relation to gratuity for employees and on limited term contracts is that if they resign, they are not entitled to any gratuity if they have under 5 years service. If their employment is terminated by the employer, or if the contract terminates on the expiry date, then they're entitled to gratuity in the usual way. The annex has wording to the effect of if an employee has 5 years service, they're entitled to gratuity, and suggests that if an employee doesn't have 5 years service, they're not entitled to any gratuity. And that's not correct. It doesn't amend the labour law, so the position is still, if they resign with under 5 years service, no gratuity, but if their employment is terminated, or if the contract simply expires, then they're entitled to gratuity in the usual way. So this provision is quite confusing, and I'm sure we'll see employers getting tripped up on that. And then finally, labour bans. So pre-2011, a 6-month labour ban was automatically imposed by the Ministry of Labour. From 2011, we saw that relaxed quite significantly. A number of exceptions were introduced, which effectively meant that labour bans were rarely imposed, particularly for skilled workers. The position under the new decrees is effectively that the circumstances in which labour bans will be imposed has been reduced even further. So long as the employee has met their contractual obligations, so they've terminated on notice, save for in a limited term contract. So if the employee has terminated their unlimited term contract by providing notice, and in the case of unskilled employees, they have 6 months service. With skilled employees, there's no qualifying period of service, then the labour ban won't be imposed. So I suppose the only circumstances really that we'll see labour bans being imposed is where an employee seeks to resign from their initial limited term contract before the expiry date. And I suppose this really ties in with what Sarah was saying at the beginning, with the whole purpose of these decrees being about mobility and flexibility and not fixing the employees into these relationships. And then finally, just to flag, there are also some provisions in the annexes to the Ministry of Labour contract which talk about the Ministry not granting a work permit for 1 year after the date that an employee leaves the UAE in certain circumstances. So this is separate to the labour bans that I've just talked about. This, or it certainly appears to be, referring to where an employee leaves the UAE and the Ministry won't allow them to come back in, won't grant a work permit in certain circumstances.